Okay, good morning, everyone. In recent years, I've seen many movies in my field, which is gerontology, and I've actually opened a blog, which is called Gero Movies. So I would like to open my presentation with a short movie clip, which I hope most of you recognize.
In telling the story of my father's life, it's impossible to separate fact from the fiction, the man from the myth. The best I can do is to tell it the way he told me.
If there was one thing you can say about that broom,
was that I was intended for larger things. I was the biggest thing Ashton had ever seen.
From the imagination of director Tim Burton.
most men, they'll tell you a story straight through. It won't be complicated, but it won't be interesting either.
So Tim Burton is a great director, and he has great movies. And the point of the movie Big Fish is basically an older person dying and his son taking care of him before his death. And the movie is about the stories that the father told his son. And the son is sure that these stories are not true, are fiction, are legends, but eventually he finds out that most of these stories are actually quite true. And that's what makes life interesting. We are basically storytellers. So in this presentation, I'm going to tell you a story, my personal story. 25 years ago, I've started to work and study the field of elder law, law and aging. And my personal experience in the last 25 years is the story that I'm going to try to tell you. And naturally, it's not almost or always a true story, but I hope it will be an interesting story. And the most important part, the fact that Oren invited me, was to share with you some insights about the future. And the only way to share with you the insights about my thoughts about the future is to share with you my experience of the past. So as usual, this presentation will be divided like anything in life into three parts: past, present, and future. And it will be the presentation that will receive the world record for self-citation. Though you will never see any kind of presentation that cited oneself so many times as this presentation, and I hope you will enjoy it. So I would like, wow, okay, technology. This is not the right presentation, but we'll survive. So I will accommodate to the current presentation. So let's begin with the past, and I would like to open with thanks to Oren. I'm sorry, I apologize. It was a similar presentation in another conference, so I'm sorry. But I would like to thank Oren and the organizers to providing me the opportunity to present. So, starting in the past. In 1993, the first edition of the Elder Law Journal, which was the first legal journal that focused on elder law and law and aging, was published. And in this journal, Professor Lawrence Froelich, in his first article in the field, made a very simple and straightforward argument. The need for a scholarly consideration of law and the elderly is great. And that was the time that I entered the field of law and aging. And it was a great time with great fascination. A lot of really excellent law professors in the United States, which you see their pictures here, were very active in the field. Many new associations and organizations like the National Academy of Elder Law Attorneys, the ABA Commission of Law and Aging, the Legal Council of the Elderly, various and new organizations, legal organizations, were starting to form in the United States in the field of law and aging. Various scholars took upon themselves to become leaders in the field. There were the first elder law conferences in Washington, D.C., which I was fortunate to attend, and the first of their kinds of elder law clinics, which focused on the field of law and aging. The ruling approach in the 1990s in the field of law and aging was what I would like to call the topical approach. So there were specific topics that legal scholars usually focused and addressed. So for example, guardianship. there was a whole field of elder guardianship, like for Professor Lawrence Froelich, which studied, wrote, and looked into age discrimination, estate planning and advanced legal planning, Medicaid and health law. So if I would summarize that period, the topical and very common approach to the field of law and aging and elder law at the time, in any textbook that you would read in the 1990s, was a series of chapters, each chapter focusing on a specific topic, which overall was viewed as the field of elder law. So if I would like to summarize that period of the 1990s, I would say that first of all, people fell in love in the field of law and aging, which was totally unrecognized or unknown before. People continued to study, to learn, to expand our notion of knowledge. And I can also say to myself on a personal level, they were very much involved in the field, on the ground, in representing older people in the courts in an attempt to advance their rights. So this was the first period in the past. The second period was basically for myself personally in the 2000s. I finished my PhD, became an academic, and adopted my self-identity as someone who specializes in the field of law and aging. And I started to think of how can I contribute to the field and what was basically missing. And from my personal and very subjective point of view, I found certain key fields that I thought that were missing in the field of law and aging. The first thing that I was thinking that I personally missed during my studies and my entrance to the field was a sense of theory. What is the theoretical foundations of the field of elder law or law and aging? Is there any coherent global foundational theory that identifies the field of the rights of older persons as such? So I took upon myself to edit the book that you see on the slide, which is called Theories of Law and Aging, which was basically a collection of legal scholars from different approaches, which each one tried to present his or her theoretical approach as a foundational approach to the field of law and aging. So we had a feminist approach, and we had a disability approach, and we had a therapeutic jurisprudence approach. So various scholars from their own personal background and theoretical approach try to anchor the field of law and aging within those theoretical approaches. However, there were some new and novel and unique approaches. For example, my personal multidimensional approach, which tried to basically invent a new model that will try to emphasize the uniqueness of the field of law and aging and human rights of older persons. So that was the first project, which is actually a project that I think there's a lot to do. I think we're still missing a unique theoretical frameworks to define and to better understand what is unique and different in the field of law and aging than other fields of law. The second aspect that I found was missing is the international aspect. Now, this audience is certainly not the correct audience to speak, but historically, law and aging was a very American field of law. So in the 1990s, if you went outside US or North America, it was very difficult to find legal scholars or scholars from other fields who would self-identify themselves as experts in the field of law and aging. Elder law was unheard of in Europe, Asia, Latin America. It was simply unheard of or unknown. And the fascinating thing was that during the 2000s, there was a huge wave of new scholars in Europe, Latin America, and Asia who started to look into the field of law and aging in their own countries. So you have example in Canada, in England, Australia, Sweden, but many other countries around the world. More importantly was the development of comparative legal studies. So for example, in the field of guardianship, there's a whole new range since the early 2000s of comparative studies which compare the different law reforms in the field of elder guardianship around the world, which can teach us a lot about why, how law values develop. And finally, the most important thing, which relates to the previous lecture, is the international human rights arena. Unlike persons with disability, older people do not have their own international convention for human rights. And one of our challenges and adventures we took upon themselves, our small community of elder law scholars, were to try to change reality and advocate and actually work to establish a new international convention on the human rights of older persons. And actually, although we still don't have a convention, we have moved significantly forward. Since 2011, there's an open-ended working group at the UN level. Since 2014, there's an independent expert of the UN High Commission of Human Rights. In America, there's a new regional convention for the rights of older persons of the Organization of American States. And the African Union, there's a new additional protocol for the rights of older persons, which is still not enforced, but has been enacted and is now on the ratification level. So you can certainly see a whole new movement on the international arena to advance, promote, and establish new international human rights standards specifically targeting the rights of older persons. Another thing that I found that was really missing in our field was empirical legal studies. I don't know what's your experience in the international world, but at least in Israel, and I think it's very much true in the US as well, we legal scholars are empirically disabled. I have LLB, LLM, PhD in law. In none of these educational periods did I ever study research methods, statistics, or any rigorous empirical studies approach. And this is fascinating to anyone who comes from the non-legal arena, which research methods and empiricism is the foundation for science. So as I entered more and more into the social sciences and gerontology, I advocated, and not only advocated, but took upon myself to go into what we called empirical legal studies. I took upon myself to do various examples of empirical legal studies. In this presentation, you see example of empirical legal studies in the European Court of Justice. For the purposes of this presentations, which you don't see, I gave example from empirical legal studies on dementia and dementia in courts, and how courts empirically approach and analyze cases of persons with dementia. The next challenge that I want to present to you is how to bring together lawyers and physicians. One of the fascinating things, and once again, this is an audience which is basically an audience that is quite obvious and natural to you, but in many cases in academia, the disciplinary borders are very, very difficult to break down. Talking with my, for example, colleague, Professor Tweed Wolexky, who's a geriatrician, but not a lawyer, and talking with myself on a daily level is very, very difficult in Israel. We each one live, work, write, communicate, study, research in our own disciplinary silos. Bringing together and doing a real interdisciplinary, multidisciplinary, and transdisciplinary academic work in the field of law and aging is very, very difficult to do in real life, unlike talking. So once again, I've wrote several conceptual pieces to try to conceptualize how to bring together a knowledge of law and aging. I called it geriatric jurisprudence, and I wrote several pieces on what is the essence, the theory, and the justification of establishing a new field, basically, of interdisciplinary knowledge, which we called a geriatric jurisprudence. And not only did we advocate it on the theoretical level, but we were actually involved in some empirical studies, which we interviewed both physicians and lawyers and asked them, how can we cooperate and work together? So to finalize, the second stage is, I think we certainly needed to identify the gaps in the field. We needed to do some empirical study. We needed to collaborate, and we needed to support and build new leadership. So now I come to the third and final part of my presentation. So where are we going from here? what is going to be the future, and how is my next opening lecture of this conference in 2043 in Tokyo will look like. I would like to propose to you a few directions. The first direction is ideology. After certain years in the field, I think that many times when we work in science and academia, we elude ourselves that we are objective, neutral, and lack ideology. At least in my field of law and aging and rights of older persons, I believe we need ideology. So in recent years, I started to develop an ideological approach to the field, and I call it ageism. I try to copy feminism, and I argue that a lot could be learned on how science could be influenced and shaped by ideology. The ideology is anti-ageist, is aware of the social construction of old age, and is aware of the way we as a society view older people or approach older people with our biases, prejudices, and stereotypes. So we need to be aware of that and combat that through ideology. The second approach, or the second direction I would like to propose to you looking into the future in the field of law and aging, is measurement. How do we know if in any specific country, jurisprudence, law system, the rights of older persons exist and honor? Once again, we try to develop an index, a measurement, an objective tool that can actually answer the question to what extent rights of older persons exist and honored. So we developed something that we call the first International Older Persons Human Rights Index, which is called IOFRI. We actually published our first pilot study, which was published in the Gerontologist only recently. And the idea and the project in the coming years is actually to measure the different aspects of human rights of older persons across the globe to provide an objective picture and a comparative picture what is the state of human rights of older people. Before last, I would like to propose another direction in the field of law and aging, which what we call intersectionality. I think one of the fascinating aspects of aging is the diversity. So when you talk about older persons and you say, for example, we have a 93-year-old woman, what do we know about that woman and what could we say about her woman only based on her chronological age? And the simple answer is basically nothing. However, we do know that not only is she 91 or 93, which is considered old, but she's also a woman, which automatically, from a gender perspective, tells us about how she's viewed by society in certain cultures. But what about if she's widowed? Or what about if she's a person with color? And what about if she has also mental disability? These accumulations of aspects raises very, very interesting questions and legal issues about the aspects and the impact of intersectionality in different aspects, and specifically in the medical and health context. So, for example, we have been engaged in research about issues about aging with disabilities, for example, of aging prisoners, and various other intersectional populations, which raises significant and fascinating questions about the rights of older persons within specific cultural and intersectional context. Finally, I would skip this specific topics, and I'm very fortunate that my previous lecturer contributed to a book that I was part of the editor, which is called The Law and Ethics of Dementia. Certainly there are new and specific issues and topics that needs more research and more knowledge. Dementia is certainly a field that needs much more attention from human rights and empirical studies. Economic aspects and financial aspects of gerontology and rights of older persons. Technology and the rights of artificial intelligence. As we know, we are only starting to see the implications of technological developments with regard to older persons. And I assume that in this conference, in future and more recent presentations, there are various others specific topics that there's a lot of place to focus, study, and research. So, to conclude, I would like to end my presentation once again with a short scene from one of the best movies in my field, which you will see shortly.
All his life, Carl Fredrickson dreamed of adventure. Today, his adventure is finally taking off.
So I hope we try to look at our older persons in a different way than we used to look, and certainly face the future challenges of the rights of Carl Fredrickson. Thank you very much.
Are there any questions? Well, I'd like to commend you for taking the initiative and working on the aging. I just want to maybe you can extend two things. One, in terms of older people or elderly, since we're all going to be there sometime, and hopefully it's going to be older and older. Are you putting a frame of age on something? Are you looking into how the future, in terms of those older who are older, they may be less dementic, but they may have other problems? And since I come from the health professions, I can see a lot of other issues that need their rights, and not necessarily before you get to dementia, you can do things to prevent it. And those are those rights too that we should, like we have the babies, we've given them things to avoid, to prevent things. What about doing the same for the elderly?
Yes, well, thank you for the question. I think it's always one of the challenges, as one of the questions that always raises in our field is, who are these older people? And naturally, rights of older persons is a life course perspective. So what you do when you're young always affects what you're old. But there are two answers for this question. One is the simple sociological answer, and I'm sure most of you know this answer. The answer to the question who is old is basically the square root of your age times 10. So when you come to 9-year-old children and they ask you, and you ask them who is old, it's the people at the age of 30. For them, that's really old. So everyone in this room is basically old. And when you come to the people at the age of 25, it's the people in their 50s. And you know already what's happening. So when you come to the people at the age of 49, it's the people in 70s. So basically, the nice thing about our field of aging is that everyone is old. Everyone in this room is old, because there are always those younger people who look up, and for them, we are old on the one hand. On the other hand, the absurdity is that no one is old. Because if I would ask in this room, who is old, who defines him or herself as old, nobody does so because of ageism. Nobody wants to be viewed as old. So there's a nice absurdity in the case that on the one hand, everybody is old and wants to age, but on the other hand, nobody wants to identify or self-identify as old because of the stigma and stereotype. So the approach we are usually taking is old is one of two things. One, it's either the chronological legal age of being old. So for example, it might be their entitlement age for old age pension. So for example, in Israel, 67 would be considered old. You also received a document from the government which tells you that you are senior citizens, if you like it or not. So that's one approach. The other approach is a more cultural based, whenever society treats you as an old. So for example, today I went up to the train, which was very crowded, and I stood, and some young chick, I apologize for the sexism, stood up and said, maybe you want to sit down, sir? And I looked to see who is she talking to. So she was talking to me. So you can see the complexity. So it's both the formal chronological, but also a culturally constructed.
Well, one of the reasons I was trying to understand is, are you, as the initiative you're taking with the aging and law and bioethics or ethics, are you trying to look what is specifically unique to the aging as opposed to other disabilities? Like, I would say, why would you need the law on aging if you have dementia has its own disability convention? So,
yes, that's again a very fascinating question, and I must admit that in the discussions at the United Nations, there were some voices that argued, why do you need a unique convention for rights of older persons when you need and when you have such a wonderful convention of rights of persons with disability? And the answer is twofold. First of all, most of people or older people are not necessarily disabled.
Well, I'll just give it as an example.
Right. But the other thing is that the viewpoint and interests in politics of agivists like myself are not always the same as the ideology of persons with disabilities. And I will give you one example, but there are various examples. In the context of substitute decision-making and supported decision-making. For us in the field of aging, advanced legal planning and substitute decision-making based on previous and past preferences are not always bad or evil, and sometimes are quite a legitimate and appropriate alternative to supported decision-making. While the persons with disability movement, for them, supported decision-making is a very key issue, and for them, a priori at least, substitute decision-making is connected to something that is not necessarily with human rights of persons with disabilities. And there are other issues, for example, institutional care or residential care, when sometimes you can see, and it was fascinating to see how times these two movements not always view or understand or construct human rights on the same lines. So it will be interesting to see in the future how it works.
Great, thank you very much.
Thank you.